right, thank you very much. Well, it's my understanding that the first order of business is that the defense wishes to present a pretrial motion. Is that correct?
Yes, Your Honor.
And is the prosecution ready to respond?
Yes, Your Honor.
All right, you may present your motion.
May I proceed?
You may.
Good afternoon, Your Honor. The defense moves to exclude the statements made by Cameron Aubrey on March 7, 2016 from evidence of the following trial, on the grounds that it's a direct result of an unlawful arrest, it's fruit of the poisonous tree, and my client was interrogated without being read her Miranda rights. On the date in question, Officer West and my client got into an argument. Officer West became belligerent, told my client to shut up, and then unlawfully arrested her with a warrant that clearly did not match my client's description. On the way to the police station, Officer West got new information surrounding the warrant.
Are you contending that the initial detention of, is it Ms. or Mr. Aubrey tonight?
It is a Miss Aubrey.
Ms. Aubrey. Are you contending that the initial detention was the thing that was wrongful or unconstitutional, or was it the formal arrest under the arrest warrant?
Your Honor, the police misconduct in this case would be the unlawful detention of my client, Miss Aubrey.
All right, thank you.
Thank you. On the way to the police station, Officer West got new information surrounding the warrant that further did not match my client. At that point, Officer West turned the car around, but never told my client she was no longer a suspect or under arrest. Officer West went on to interrogate my client and attempted to provoke an incriminating statement from my client by berating her. Miss Aubrey...
What kind of interrogation, what questions were asked?
Your Honor, Officer West said to my client, "It's your lucky day, but I still think you're abusive to your cook." In the case of...
Is that a question, or is that just a statement?
Your Honor, in the case of Rhode Island versus Innis, the Supreme Court ruled that an interrogation is words or actions on the part of the officer they know are reasonably likely to elicit an incriminating response. It's not specified that they have to be questions, only a statement made by an officer they know will elicit an incriminating response.
So in your view, a challenging statement likely to elicit the response is equivalent to an interrogation?
Yes, Your Honor. Officer West and my client had an almost identical argument at the restaurant, and Officer West brought up the same argument again in the police car, and would reasonably know that my client would respond to this questioning.
All right, thank you.
Thank you. My client responded to this verbal abuse by saying, "I don't know who you think you are, but you need to understand something. Everything under that roof is mine." Furthermore, my client was never placed under the protections of Miranda, which is necessary for any custodial interrogation. Therefore, my client's statement must be excluded because there's a clear violation of her Fourth and Fifth Amendment rights.
Well, counsel, let me ask you this. Just a few months ago, half a year or so ago, the U.S. Supreme Court decided the case of Utah versus Streif. That case seems to be very, very close to the facts which are presented in this motion.
Your Honor, our case is clearly distinguishable from that in Utah v. Streif in that the police misconduct in Utah v. Streif was an unlawful stop, not an unlawful arrest. And in the case of Utah v. Streif, there was the presence of an intervening circumstance, which in our case there are none.
Well, you say with an unlawful stop and an unlawful arrest both. That's your position now?
Your Honor, there was an unlawful stop in Utah v. Streif. In the current case, it was an unlawful arrest.
When did the arrest take place in this case?
In the current case, the arrest took place after Officer West received an invalid arrest warrant.
All right, well, you're familiar with the Herrera case?
Yes.
Isn't there a good faith exception to the invalidity of the warrant?
Your Honor, in the case of Herring versus United States, the Supreme Court ruled that an officer acting in good faith, this evidence obtained would not be excluded. However, Officer West was not acting in good faith when he arrested my client. He was given a search warrant, and one of the three factors on that arrest warrant did not match my client's description. And after seeing that substantial difference, Officer West didn't inquire further.
But as I understand the facts, Officer West didn't have the actual warrant in his or her hand. It was information reported by the dispatcher, correct?
Yes, Officer West was given...
How was Officer West to know that he was not acting in good faith when he arrested the defendant?
Well, Your Honor, out of the three factors given to Officer West by the dispatcher, one of those factors clearly did not match my client. And after seeing this substantial difference, Officer West didn't call back and inquire further, asking if the person in the warrant had scars, markings, or other signifying features. He simply placed my client under arrest.
What was the feature that didn't match?
Your Honor, later, are you referring to in the initial warrant or the information that came over the radio?
Well, the initial, I heard you say that when the officer got the information about the arrest warrant, that one of the descriptors that was reported to the officer did not match the suspect.
Yes, there was a weight difference.
A weight difference. How big was the weight difference?
20 pounds, Your Honor.
So do you think somebody is so discerning they can tell the 20-pound difference and suspect that maybe this isn't the right person?
Your Honor, Officer West was in possession of my client's ID, which would have her weight depicted on it. However, even if my client would have lost or gained the weight, which is a possibility, a reasonable officer acting in good faith would inquire further when there is any substantial difference on the warrant in their possession and the person in custody.
All right, thank you.
Thank you. In the case of Herring versus United States, a police officer was told that his suspect had an outstanding warrant. He placed that suspect under arrest and found illegal substances. It later came out that there was no warrant. However, the Supreme Court ruled that because the officer was acting in good faith, there was no police misconduct that needed to be deterred. Now, as previously mentioned, this is clearly distinguishable from the case at hand, and that Officer West was not acting in good faith. Therefore, in accordance with the case holding of Herring versus United States, my client's arrest should be classified as unlawful, and any statement that is a result of it should be excluded under the fruit of the poisonous tree doctrine. In the case of Taylor versus Alabama, a suspect was unlawfully arrested without probable cause or warrant. 6 hours later, under the protections of Miranda, the suspect signed a written confession. But the Supreme Court ruled that this confession was not admissible because there was no intervening circumstances to attenuate the police misconduct from the discovery of evidence.
Well, the prosecution, as I understand it, is going to argue that there's an attenuation here, that there's no causal link between the unlawful stop and the discovery of the evidence not to be excluded. How do you respond to that argument?
Your Honor, there are no meaningful intervening circumstances to attenuate either the unlawful stop or, in which the defense is arguing, the unlawful arrest. The prosecution may attempt to say that the finding of an invalid warrant would act as an intervening circumstance. However, that happened before the police misconduct of the unlawful arrest. Therefore, it cannot be used to attenuate police misconduct. May I proceed, Your Honor? Thank you. Your Honor, the case holding of Taylor versus Alabama is almost parallel to our case, in that Miss Aubrey was unlawfully arrested without probable cause or warrant. And as a direct result of this unlawful arrest, my client was interrogated. There are no significant intervening circumstances to attenuate Officer West's police misconduct from my client's statement, therefore it must be excluded. Even if Your Honor finds that it was not an unlawful arrest and my client's statement was not fruit of the poisonous tree, my client was still interrogated without being read her Miranda rights. In the case of Thompson versus Keohane, the Supreme Court ruled that custody is determined by two factors. First, the circumstances surrounding the interrogation, and second, given those circumstances, would a reasonable person feel they are at liberty to terminate the interrogation and leave? Your Honor, Miss Aubrey, a reasonable person would in no way feel she was at liberty to leave. She was locked in the back of a moving vehicle and never told she was no longer a suspect or under arrest. Officer West went on to interrogate my client without placing her under the protections of Miranda. Your Honor, my client's statement should be excluded because it is a clear violation of her Fourth and Fifth Amendment right. Miss Aubrey was unlawfully arrested without probable cause or warrant, and then interrogated without being placed under the necessary protections of Miranda. Therefore, on behalf of my client, Cameron Aubrey, the defense asks that you grant our motion and exclude the statements from the following trial. Thank you, Your Honor.
All right, thank you, counsel. I'll hear from the prosecution.
Yes, Your Honor. Your Honor, may I begin?
You may.
Your Honor, prosecution opposes the defense's motion to exclude the statement, quote, "I don't know who you think you are, but you need to understand something. Everything under that roof is mine." And as will be further articulated, the defense's exclusionary rule argument fails as there is sufficient attenuation between the allegedly illegal detention and the defendant's statement. Further, the defense's Fifth Amendment argument fails as the defendant was not in custody nor being interrogated when the statement was made. Now, turning to the exclusionary rule. To determine attenuation, the court must get three factors as noted in Utah v. Strife. Number one, the presence of any intervening circumstances. Number two, the degree of police misconduct. And number three, the amount of time to the unlawful stop and the discovery of evidence. Your Honor, the balancing of these factors weighs heavily in favor of finding attenuation and not excluding the evidence. Turning to the first...
What about the invalidity of the warrant that the officer relied upon?
Well, Your Honor, this was still a valid warrant. Erroneous or not, this warrant still broke the causal chain between the stop and the defendant's statement, as the defendant was no longer being detained, but being arrested for petty theft.
What about the argument that this defendant was interrogated after the warrant was found to be invalid?
Well, Your Honor, Rhode Island v. has held that interrogation or any words or actions on the part of an officer that an officer should have known would have been likely to elicit an incriminating response. There is no evidence on the record to show that Officer West would have known his mere offhand remark would have been likely to elicit an incriminating response, as in fact we have evidence to the contrary, as minutes prior the defendant was vehemently defending himself by insisting the warrant was not for him.
What about the fact that the statement was made after or during a time when it was really impossible for the defendant to get out of the car, police car, on the way back? There was no handle on the inside of the door, as I understand it. Surely the defendant was not free to leave at that time and thus still under arrest, was he not?
Well, Your Honor, people respectfully disagree, as Thomas v. Keohane defined custody as any circumstances where a reasonable individual would have felt he or she was not at liberty to terminate the investigation and leave. In the case of Barr, there are 4 indicators to prove that any reasonable individual would have felt at liberty to leave. Number 1, the police dispatch claiming the suspect in the warrant possessed a tattoo. Number 2, the Officer West checking for tattoos and finding none. Number 3, Officer West turning the police car around. And number 4, Officer West stating, "It is your lucky day." Now, Officer West had stopped the moving police car to check for tattoos. At this time, when Officer West found none, all the defendant had to do was simply ask Officer West to leave the police vehicle if the defendant never did. This was no weak, lazy defendant afraid of authority. As minutes prior, the defendant was vehemently arguing with Officer West.
Don't you think the defendant really wanted to get back to where he'd been picked up?
Well, yes, Your Honor, as he was only 10 minutes away from the restaurant. It is unreasonable for an officer to just kick the defendant out of the car, force him to call a ride, or walk back to his restaurant when it was only 10 minutes or less away. Now, turning to the first factor, an intervening circumstance. In strife, the valid arrest warrant qualified as an intervening circumstance, and as previously articulated, the valid arrest warrant in our case still qualifies as an intervening circumstance as it broke the causal chain of connection. Moreover, both Officer West and the defendant heard that the suspect in the warrant possessed a tattoo.
But the Utah case had a significant difference to it, huh? And in that case, there was no debate that the arrest warrant that was found after the detention was in fact valid.
Well, Your Honor, notwithstanding the fact that the warrant was for a different defendant, this distinction is without legal significance with respect to this factor because the warrant still broke the causal chain as the defendant was placed under arrest and no longer being detained. Moreover, both Officer West and the defendant heard over the police radio that the suspect in the warrant possessed a tattoo, and Officer West had concluded that the defendant had no tattoos. Therefore, this serves as a second intervening circumstance, as the statement was voluntary, not under police coercion, as the defendant was no longer in custody. Turning to the second factor, police misconduct. Your Honor, the only potential misconduct occurred at the time Officer West stopped the defendant. And while it can be argued that Officer West had the duty to stop the defendant from disturbing the peace, even if Officer West lacked proper cause, the United States Supreme Court held in strife that the misconduct must be more severe than the mere absence of proper cause. Concerning Officer West's conduct in arresting the defendant pursuant to a valid arrest warrant, inherent in the United States, the Supreme Court held that an officer is acting in good faith, and there is no misconduct to be deterred if the officer has objectively reasonable reliance on the erroneous warrant. Your Honor, the identity mistake in the case of Barr was objectively reasonable because there were 3 descriptors provided to the officer. 2 of them, the name and the height of the suspect, matched almost identically, while the 3rd weight was certainly negligible. Moreover, concerning Officer West's good faith, as soon as he received information regarding the tattoo, He pulled the car over, he checked for tattoos on the defendant, and when he found none, he immediately turned the police car around. Your Honor, in strife, the fruit of the poison tree doctrine only applies when the deterrence outweighs substantial social costs. Officer West committed no flagrant police misconduct, therefore, excluding the evidence will not serve the purposes of the exclusionary rule.
Well, let's talk about the flagrancy of the conduct. I mean, as I understand the facts, there was really no reasonable suspicion that was articulable. No facts were articulable by the officer at the time of the initial detention. He was merely in an argument with the defendant. And then he gets in the car and he gets information that turns out to be incomplete at best. And so we have an unconstitutional stop. We have at least negligent or reckless conduct by either the dispatcher or the officer. And are we going to excuse all of that police misconduct, whether it's negligent or not?
Well, Your Honor, Heritage United States provides that flagrant police misconduct includes systemic error or reckless disregard of constitutional requirements. In regards to the warrant, this is only isolated negligence, as the reliance on the erroneous warrant was remedied within 10 minutes or less. The police station received further information related to Officer West. Officer West then acted on this further information and turned the police car around, showing no systemic error, as this all took place within 10 minutes or less. Further, there is no constitutional requirement for an officer to follow up with further inquiry once receiving an arrest warrant, showing no reckless disregard of constitutional requirements. In regards to the initial detention, Utah v. Sheriff held, as previously articulated, that there must be more than lack of proper cause to constitute as flagrant police misconduct. Your Honor, this is a very isolated situation, unique to the facts of the case. Officer West was a patron at the restaurant. Officer West was approached by the defendant in the middle of a phone call. The defendant began yelling and arguing with Officer West, and the defendants continued to argue even when Officer West stated to calm down. Officer West's subsequent action was part and parcel of the initial detention that was deemed not flagrant enough as a standard in Utah v. Strife. Furthermore, Your Honor, there was no violation of the Fifth Amendment. As previously articulated, the defendant was not in custody, as Officer West had made it clear it is your lucky day. Furthermore, even if the defendant was in custody at the time he made a statement, there was no presence of interrogation or the functional equivalent of interrogation, as held in Ryan v. Ennis. Only a mere offhand remark. 30 seconds. If a mere offhand remark is to be constituted as interrogation, this would be a chilling effect, as they would be afraid to interview anyone, including witnesses, as any evidence received could be inadmissible if such a mere offhand remark is deemed interrogation. As such, people respectfully request court deny the defense's motion. Thank you.
All right, thank you. I'll give a rebuttal to the defense.
Your Honor. May I proceed?
You may.
Your Honor, the defense does find the initial stop of our client unlawful. However, the defense is asserting that the police misconduct in this case is the unlawful arrest. Now, an invalid, erroneous warrant would in no way be classified as an intervening circumstance. In that regards, our case is clearly distinguishable from that of Utah v. Strife. It would more closely follow the holding of either Taylor v. Alabama or Brown v. Illinois, in which there was police misconduct of an unlawful arrest, but there were no intervening circumstances, so evidence must not be admissible. Opposing counsel has asserted that my client was not in custody. And they have cited the case of Thompson v. Keohane, which in the case they determined that custody is determined by what a reasonable person would believe. Your Honor, Miss Aubrey was locked in the back of a moving prison cell. She was never told that she was no longer the suspect or under arrest. For Miss Aubrey to voluntarily leave the car, Officer West would have to physically stop the vehicle, exit the car, and open my client's door. Officer West was in control of the situation from the moment he took my client's ID, and it was his responsibility to relay the information to my client that she was no longer in custody. Without Officer West doing that, no reasonable person would assume they were free to go, seeing as they could not physically leave the vehicle.
What about the prosecution argument that the statement was clearly made after the officer said it's your lucky day? It seems that the defendant knew at that time that she was no longer to be under arrest, and voluntarily made a statement, it sounds like a voluntary statement, in response to an officer's statement that was not really a question. And particularly, what about Rhode Island versus Ennis, where the officers were simply having a conversation about potential for a gun being picked up by a small child, and the defendant made a voluntary statement which turned out to be exculpatory.
Your Honor, in the case of Rhode Island versus Ennis, the officers had no reasonable knowledge that them talking about a child finding a shotgun would elicit a response from the person in their custody. For that is clearly distinguishable from our case, in that Officer West already knew my client. In fact, Officer West and my client had an almost identical argument back at my client's restaurant. In fact, that argument is what started the initial arrest. And when Officer West discovered that the person in his warrant was not my client, he went back to the same argument that started the first arrest and was looking to find something else. He was testing his luck to see if he could get my client to say something that would be incriminating.
Right.
Thank you. Your Honor, for these reasons, and looking at the totality of circumstances, the defense asks that you grant our motion and exclude the statements from the following trial. Thank you, Your Honor.
All right, thank you. I'll hear a rebuttal then from the prosecution.
Yes, Your Honor. May I begin?
You may.
Your Honor, defense counsel contends that this illegal arrest is enough to reach the level of flagrancy to outweigh the substantial social costs of not excluding this evidence, and relies on Taylor v. Alabama to prove this point. However, in Taylor v. Alabama, there were no meaningful intervening circumstances. In the case of Barr, there were not one intervening circumstance, but two meaningful intervening circumstances. Number one, the valid arrest warrant, or when you're not, this warrant was still valid. Number two, the voluntary statement that was not subject to police coercion. Your Honor, the reliance on the erroneous warrant was simply isolated negligence. If Officer West was trying to exact his revenge or act on a personal vendetta, this begs the question, why then did he turn the police car around once he found out further information? He could have lied about the tattoos altogether, or he could have waited till he got to the police station to check for tattoos. But no, he immediately turned the police car around once he found out that there were no tattoos. Furthermore, Your Honor, defense counsel relies on an erroneous legal standard in regards to interrogation. Defense counsel cites that Officer West intended to elicit an incriminating response. However, the intent of an officer is irrelevant, for the actual standard is any words or actions that a police officer should have known would have been likely to elicit an incriminating response. As previously articulated, there is no evidence on the record to prove that the defendant would immediately fold after a mere offhand remark. And as previously articulated, once again, Your Honor, this is an isolated situation unique to the facts of the case. Officer West was not targeting any individuals. Officer West was not going out of his way to persecute any individuals. There was no blatant police misconduct that outweighs substantial social costs. The exclusionary rule was designed to prevent, not repair. As such, people respectfully request the court deny the defense's motion once again. Thank you.
All right, thank you, counsel. Under the rules of competition, each team is permitted 30 seconds at this time to consult with their advisors to determine whether there are any rule violations that need to be brought to the attention of the court. Does either team wish to do that?
None from the defense, Your Honor.
None for the prosecution, Your Honor.
All right, thank you very much. The court then will go ahead and rule on the pretrial motion. Well argued on both sides, but I think it's a very close case. But to begin the analysis, I think we have to conclude that when Aubrey was detained by Officer West at the outset, he was unquestionably detained for constitutional purposes. And being detained at that time without any articulable facts which suggested any criminal activity was a clear violation of defendant's Fourth Amendment rights. There just were no facts which would justify that detention. The detention occurring, of course, when the ID was taken and Aubrey was told to sit tight while he checked for a warrant. Usually that would be the end of the analysis. The constitutional violation would necessarily require the court to exclude the statement made thereafter. But here the prosecution has argued that the initial unlawful detention was attenuated by some intervening event, namely the discovery of the arrest warrant. Now, it turns out that the Strife case isn't quite on point because this particular arrest warrant was unquestionably for a different individual, as later discovered. But at the time, Officer West had no way of knowing that. I'm told that there was a 20-pound difference in weight. I suggest that not observing that difference in weight is negligent at best and not kind of an intentional misconduct, which the court would find incriminating or unlawful. So, on balance, I think the statement made by Mr. or Ms. Aubrey in the police vehicle after he was told or she was told that she was no longer under arrest, even though the car was locked, I think Aubrey understood full well at that time that there was no further detention in place. The statement was voluntary. So on balance, the court finds that the police conduct here is not so severe that it would warrant the exclusion of the evidence.